A very good morning to one and all present here. It gives me immense pleasure to welcome you all to this two-day workshop on intellectual property rights, organized as part of the ongoing celebration of 75 years of Faculty of Engineering, erstwhile the Alvag Engineering College, by the Department of Mechanical Engineering, Faculty of Engineering, the Albag Educational Institute, and sponsored by the Council of Science and Technology, Lucknow. Today marks the beginning of 2 days dedicated to learning full discussion on how intellectual property can shape the future of research and innovation. It has commenced this workshop on stand for the university prayer.
टीनेज में हर बेशी सब बंद का पिया रे हे दया सब पार हम जीवन रे दया सब
Now, to set the tone for the event, I would like to invite Mr. Manoj Kumar sir to deliver the introduction to the workshop.
A very good morning to all present here. It gives me great pleasure to welcome you all to this two-day workshop on intellectual property rights organized by the Faculty of Engineering, Dalbagh Educational Institute, in collaboration with the Uttar Pradesh Council of Science and Technology. At the very outset, I would like to extend my gratitude to our Honorable Director, Sir Professor C. Patwardhan, whose vision and leadership continue to inspire academic excellence and innovation across the institute. I am also grateful to our respected Registrar, Sir, for his constant support during the planning and execution of this workshop. I am also thankful to our esteemed Treasurer, Ma'am, for her continuous support in the financial planning of this workshop. I welcome our respected Dean, Sir, Professor D.K. Chaturvedi, Sir, and our respected Head, Sir, Professor Rahul Swaroop Sharma, Sir, for their presence and continued support in all our workshop initiatives, without whom the workshop would not be possible. A very special welcome to our distinguished speakers. Your contribution will help us explore the evolving landscape of intellectual property and its crucial role in shaping the future of research, innovation, and entrepreneurship. This workshop has been conceptualized with a threefold objective. Number one, to sensitize participants to the fundamental and strategic importance of intellectual property rights. Number two, to equip participants with practical knowledge on how to protect and commercialize their creative outputs. Number three, to create a platform for sharing innovative ideas enabling interactions with experts, and fostering collaborations. Over the next 2 days, we will have enriching sessions by eminent speakers who will cover diverse aspects of IPR from patents, copyrights, trademarks, and design considerations to innovation strategies, technology transfer, and entrepreneurship. We will also have a special quiz dedicated to students and participants where innovative ideas will be showcased and the best contributions will be recognized. I am delighted to see the enthusiastic participation from faculty, students, researchers, and professionals, both from within the institute and other institutions. Your presence reflects a growing realization that intellectual property is not merely a legal tool, but a driver of innovation, economic growth, and societal impact. I encourage all participants to make the most of this workshop, ask questions, interact with the speakers, share your ideas, and engage actively in the discussions. I hope that these 2 days will leave you not only more informed, but also inspired to convert your ideas into valuable intellectual assets. With these words, I once again welcome you all to the workshop. Let us embark on this journey of learning, innovation, and intellectual exploration together. Thank you.
you, sir, for laying the foundation of what promises to be a deeply enlightening workshop. We are privileged to have among us Professor T.K. Chaturvedi, sir, Dean, Faculty of Engineering, Dalbagh Educational Institute. I now request sir to address the gathering and share his valuable words of wisdom.
All of you. Honorable Director DEI, who gave us this chance to organize this workshop permitted in the campus of DEI. My dear colleagues, invited guests, experts of IPR, and the most important, my dear students, the innovators, inventors of the future. IPR, the topic taken today for this workshop, is very, very important, especially for the engineers, because the engineers most of the time do their work behind the curtain. For example, if you see, almost all the medical instruments designed and developed by engineers, but doctors, when they use, they get popularity, but the engineers will not get any credit of it. So if you want to take the credit of your ideas, your brainchild, innovations, go for intellectual property rights. Protect those ideas, protect those products which you develop during your projects. For example, you might be working on DETT projects, major projects, REP projects, and so on. So whatever the project you are developing, there must be some brain ideas, some new innovative ideas which you try to implement. And if you try to implement those ideas and successfully demonstrate them in front of the society, why don't you protect it so that nobody can duplicate it, nobody can copy it, right? If you will not protect your ideas, then that idea or that product will be the gift for your competitors. They will use those ideas and commercialize it and sell it and get the profit, and you will not get anything. out of it. So this is the right time when you can implement your ideas, develop the products, develop your new designs, and protect it. There are different types of intellectual property rights. For example, the patents is one of them. You can ask for patents, whatever you develop, and that is for products. For designs also, we have IPR, copyright, trademarks, GI. So lots of different sections where the intellectual property rights can be taken and you can protect your ideas. I will narrate a couple of stories to you so that you can understand the importance of this IPR, how much the intellectual property rights are important for budding engineers in today's time. This is the story of a budding artist named Anya, who creates beautiful and unique digital art. When her art gains popularity, a rival company tries to use her designs in their products without permission, and that leads to a conflict over traditional or intellectual property rights. With the help of IP lawyer, she filed a case on that and get a good compensation, rightful compensation, and ensure her continued ability to innovate and share the art with the world. So this IPR protected that idea or the arts developed by that budding artist. If IPR facility will not be there, then you cannot get the money, okay, cannot get the profit from your brain ideas. Similar incident happened with South African executive named Nkosana Makate, the man who invented Please Call Me for Vodacom in 2001. And this is a service that went on to generate over 200 billion business in the revenue for company, but that person did not get the proper compensation from the company. So again, he filed a case against the company and he got a very good amount from the company just for this innovative idea. Hence, it is very, very important for engineers to protect their ideas using IPR. Most of us might think IPR is the job of lawyers. This is the misunderstanding in the young minds. IPR is the engineer's strategic weapon which you can use to earn money. So let us commit today to foster a culture where groundbreaking innovations goes hand in hand with a smart strategic protections. I request my budding engineers to ask relevant questions and clarify your doubts from experts and take full advantage of this workshop so that in future you can also apply for patents, apply for IPR protections so that your ideas will be useful for the society and you can also earn money out of it. Thank you very much. Thanks one and all.
Thank you very much, sir, for your inspiring address and constant guidance. We shall now break for a short high tea. Kindly reassemble after the tea break as we'll begin with our first technical session. There is an arrangement for all the participants for the refreshment, so kindly collect your refreshment outside this hall.
Okay, so good morning, Radha Swami. So this is Dr. Rajiv Ranjan, and first of all, I'd like to thank organizer, Faculty of Engineering for inviting me here for such a novel talk. So I think in the morning session, I think 10:45, our dean already briefed about what is the pattern, why it is important. So continuing to the further talk, so this is IPR, that is called intellectual property right. So what is intellectual property right? I think everybody is knowing. Intellectual means something who derived from the mind, wisdom, brain. That is called intellectual. And property, this is also property, this is also asset. You are thinking that only building, money is asset. This is also asset because this is the intellectual. You have developed from your own brain, mind. And right, you know already. So if you see the different properties like creation of mind, it may be symbols, literary, artistic work, and inventions. So these are all creation of mind. Whatever we are discussing, they are all creation of mind. Okay. Okay, so my topic will be confined to the patent only. But this is the some brief. What is IPR? So already everybody is knowing these are legal rights. Why you are telling legal? Because you are filing in some of the organization, maybe patent office is there, copyright office is there. Okay. So rights they protect intangible creation of the human. Why I am telling? Because now it is the era. It is the era to whatever things are there in your mind, you have to what call? You have to make it in form of IPR. Like suppose you have creation something, but you have not filed as a IPR, so no use. Like publications only people can refer for a reference or for knowledge, but this will give money also. Because nowadays, see, I am just giving one example before going to start. Like one of the professor from our institute, Professor Bhojwani, SS Bhojwani, he is the ex-director of this institute. So he has written one book that is called Plant Tissue Culture. And when I visited MIT Boston, in that library also I found that books. So his book is so much renowned that every library of the country are keeping in their library. And if you talk to him, he was telling more than 10 lakh per year I am getting as a loyalty. As a royalty. He is not telling a clear figure. I am telling more than 10 lakh per year. He is getting royalty as a part of IPR. So that's why I am telling it's time to see many pools are created many things, but they don't know where to file, how to file, where to communicate. So that's why I am telling this particular workshop is very important for you people. I think those who are doing BTech, MTech, and also PhD. So this is you can see that copyright, trademark, patent, industrial design, and also here I have not included. It is called GI. That is called geographical indication. Like PETA. PETA of Agra is also granted as a GI of the. So that's why I'm telling GI is you're not so important. That's why I'm telling only copyright, trademark, patent, industrial design. So what is the you can see what is the different reasons to provide an incentive to individual for new creation. So you are going to get incentives, then to accord due recognition to the creator and inventors. So because you are filing something, if it is granted, so you will get royalty also, incentive also. Because that's why just our dean is telling in the morning, when you commercialize, you will get money. Third is to ensure material reward for intellectual property. Like see, whatever everything like fan, laptop, whatever gets able to see these things, everything is patented. Once upon a time. Even brush, pen, this one, all are patented product. If you see in the internet or Google search, so you see everything is patented. Lastly, to make available genuine and original products. So I will tell you what are the different criteria, how the things to be patented. Okay, so you can see here. So in case of patents, invention is product, process, materials, composition. So these are things because my talk is not confined to the industrial design, trademark, copyright. So I will focus only on the patents. Okay. So here this is the validity. Validity means what is the duration, how many years you can to get the patent for, like you can see patent 20 years, maximum time period is 20 years, trademark lifelong, design 15 years, copyright 60 years. So these are different acts are there. So like Indian Patent Act, 1970 and finally amended in 2025. So these are the things. What you are creating patents, copyright, trademark, design. And these creations will be protected under different act, like Patent Act 1970, just I told you, Copyright, Trademark Act, Design Act. And finally, if you commercialize through certain systems, you will get incentives. Okay, so I am giving one example that is very interesting. That's why I just put it here. Like everybody knowing golden rice. I don't know because just sir was telling here many people are sitting as an engineer. I am not engineer. Basically, I am genetic engineer. My background is genetic engineering, biotechnology. So that's why I'm telling I am genetic engineering. Okay, so here you can see golden rice. I think most of the people maybe or might be not knowing what is the golden rice. Golden rice is nothing but it is the iron fortified rice. Because rice is a staple food. Most of the people are consuming rice either in morning or daytime as a lunch or dinner. So that's why scientists thought if you fortify iron, because or vitamin A, I am telling vitamin A, that is called thiamine rich, because most of the people are deficient in vitamin A. So if you fortify vitamin A in the rice, I think night blindness, yeah, many diseases related to vitamin A will be cured. So that's why scientists designed golden rice. Why it is telling golden? Because color is just like yellow color. You can see here golden rice. And this is the rice, you can see integrates all form of IPR, because I told 4 form of IPR. You can see trademark. So golden rice name and logo is a trademark. Patent, what is the patent in this particular rice? Because we have inserted gene of beta carotene pathway. So this is the gene. I don't know people are knowing what gene is nothing, but it is the DNA sequence. It is the segment of gene, segment of DNA, which codes for particular polypeptides. Okay, so this is the gene, because this is the noble gene, that's why people file as a patent. And see the copyright, creative, academic work, figure, paper, and data. So whatever you can see the bags are there. So this is a copyright and design, packaging, and promoter. See all form of patent is available in form of golden rice. You can see here. So generally, people have maybe either file as a trademark or patent or copyright, only one, like suppose book, only you can file as a copyright. But here, see, people have protected all the views in form of different trademark, patent, copyright, design. So these are 4 different things. This is a unique example. Like in case of golden rice, all 4 kind of IPR available in case of golden rice. Now again, I am giving example. Like this is called basmati rice. See, because I belong to the Department of Agriculture, that's why my focus will be confined to the life science, biological science. So basmati rice, everybody knowing. Basmati rice is known for the aroma, known for the scent. If you eat, I think you'll getting might be some type of scent, like some aromatic sense is there. Okay. So this rice is particularly native is India, but this rice is patented in USA. See how people sweating. Because I will tell you, patent is only confined with the one particular country, one particular geographical area. No, you cannot file patent in all countries. Yeah, you can file patent in 2 countries, 3 countries, but if you are filing patent in India, it will be only protected in India only, not protected world as a whole. So people, what they are doing, they are taking the things from India and patenting in USA. You can see here, like Rice Tech Company, they have patented rice basmati in other name in USA. So that's why so many hue and cry are there. People have thought there, no, this rice native is India. So again, later on, it got cancelled because patent even was cancelled. Somebody is filed, somebody may complain, so it will be cancelled. So this is the example. Like you can see, it is granted as GI tag in India. If you see here, it is granted as GI tag India. So that's why it is very popular in India, and everybody, I think, uses rice, basmati rice. So these are the all background. Now, again, I am coming to the basic slide. So what is patent? So patent is nothing but it is the intellectual property right relating to invention. So I am not reading the slide, just So this is the word patent came from Latin word that is called patriar, which means to lay open. Generally, what we are telling, whenever filing the things, it will be come to the public domain. Okay. So in India, it is governed by Patent Act 1970, and again it is the patent rules came into 2003. And already told you it is generally granted for 20 years for within prescribed area. So again, patent is of different types, like maybe utility patent, design patent, plant patent, and reissue patent. Suppose your 20 years is expired, so again you can file for again you can reissue by paying certain money. Okay. So now question is that what are the things can be patented? So it must be novel. Novel means kya? New. It is not. And again I am telling, meaning of patent is if anything present in the natural condition, you cannot file a patent. Anything which is available in the nature means natural things cannot be patented. You have to modify it. Like suppose if you are student of engineering department, generally you are making the product. So you are because you are creating the product, so it can be patented. But any chemicals, any gene, anything, any plant, but first time if you are discovering certain plants, it can be patented. So these are certain rules. It should be novel. Novel means it should be new one. Non-obvious. Non-obvious means it should be unique. Capable of industry application. That is also very, very important. Until unless it should have industry application, your patent cannot be filed and must not be declared a non-patentable. Again, I am telling many things are there which cannot file as a patent. Like many things, like bioweapons, nuclear energy, many things I will discuss in next slide. Okay, so you can see already told like invention, you can file the products like new machines, tools, equipment with unique functions, a smart irrigation device, eco-friendly sprays. So just I told you, sir, बोलिए. Yeah. Curcumin. Generally, turmeric contains curcumin. Yes.
I think it got cancelled. Was it cancelled or no?
Yeah.
Was it cancelled? This patent was cancelled or not? Turmeric, haldi.
Yes.
Cancel हो गया ना?
Yes, cancel हो गया.
Very good.
So many things I am telling people should know that this is the native to India. We should, but still I am telling person from other country they are coming and taking the things and patenting their own country. It is also happening. Even processes, such I will tell you, like those who belong to engineering department, they can file product as a patent. Like different product, like I already told you, like new machines, tools, equipment, you can file as a patent. Then processes, like suppose if you are making certain process and making the things easier, that can be also patented. Composition of matter, like new chemicals, I already told you, pharmaceuticals, biological formulations, like I already told you, like you can see nano-based biofertilizer, herbal things, that can be patented. Because you are mixing the things, you are designing certain things. That's why you can file as a patent. Again, software algorithm. Again, here I am telling even software can also, you can file as a copyright also. Because recently I got one copyright of one of the software I will show you. So it can be also filed as a patent. Biological invention, I already told you, whatever DNA sequence are there, gene sequence are there, if you have designed, if you have developed, it can be also patented. Like you can see microbes, enzymes, plant promoters. Like I already, in my case, 2 patents already granted in case of 2 novel promoter. Okay, so 2 novel promoter already granted and 1 promoter already I filed and published. I recently filed 1 more promoter as a just recently I filed one patent. So 4 patents are already in place, 2 already granted, 1 is filed and published, 2nd recently filed. Now you can think, see, engineering bacteria for heavy metals involved. Already we are working on that is called bioremediations. New use of known substance. I already told you, like medicinal extract, repurpose. I am telling if you are preparing and if you are proving that this is the first time you are created, so you can file as a patent. Improvement of existing invention. Again, I am telling, like suppose systems are already there. If you are improving in certain ways, then that can be also filed as a patent. Like I told you, example is improved promoter for strong gene expression. Like I am telling 2 patents in my case already granted. What is the purpose? Because in general case, suppose if particular gene is giving 10 milligram of protein. If you use my promoter, you will get 50 milligram of protein. So you can see we are going to enhance 5 times, 10 times a stronger expression. We will get more protein. That's why government has granted this kind of patent. Now question is that what cannot be patented? So already told you anything against universal law. Already law is there. If you are going beyond the law, you cannot file a patent. Like business schemes, mathematical methods, artistic creation, you can file as a copyright like thing. Invention that intend to cause disruption of public order. Okay? Mere arrangement, rearrangement, mixing. Means if you are doing certain what you call normal arrangement, something, it should be noble. If it is not noble, you cannot file a patent. Even nuclear energy, even bioweapons, even coronavirus. Even though just recently 2020 and 2019, Corona is so popular. So you cannot file a patent because it created so much high hope like that. So that's why bioweapons you cannot file a patent. Nuclear energy you cannot file because atom bomb. So that's why I'm telling you many things are there, you cannot go beyond that. Now coming to the patent administration in India. Okay, so in case of copyright, every capital has copyright office. But patent only you can file only at 4 places like Kolkata, Mumbai, Delhi, Chennai. Like suppose if you belong to Agra, you can file patent in Delhi office. Okay, so only 4 cities are available. But nowadays online facility is there. You can file patent online also. Okay, there is some rebate in prices. Now question is that who can file patent application in India? So any person claiming to be true and first invent. Again, I am telling here, already I will tell in this. If you are filing individually, if you are filing patent from the institute, you have to pay 4 times more money. If you are filing individually, payment will be reduced to 1/4. I will show in the next slide. So that's why I am telling you have to know each and every rule. Otherwise, maybe you can spend more money like that. Okay. By any person being the assignee of person claiming to true and first inventor. By legal representative, suppose if anybody died like that, if representative, they can also file the patent. So this is the head office. You can see it is called physical filing. Already I told you now you can file patent as electronic way. Like in July 2007, already started. You can file patent online also. Okay, so these are the forms. Because see, I am telling, I think this is the 2-day workshop, so maybe other scientists, other expert will tell in different, so different forms are there. Suppose if you are filling the patent form, so there are different forms are like form 1, form 2, form 3, form 26. So first you have to download the forms. Suppose if you are filing online, so you have to first fill the form. Okay, so these are the different forms, form 1, form 2, form 3, form 26. I think, yeah, you are able to see. Then you can see a collection of search from the inventors. You can search Google search because why patent is published so that people can know whether if nobody, I think maybe somebody has taken your ideas. So when it is published, so it is come to the public forum, public domain. If nobody is claiming that this is my findings, then after that it will go to the examination and finally your patent will be granted. If nobody claim, nobody file any comments. So these are different steps, like you have to fill the forms, then you have to go for the different, we have, I think, different slides. This is not so much visible. Okay. So again, I am telling, so see the difference. Online patent filing is called e-filing and offline filing. So mode of submission is done through the official patent that is the website IP India, IP Indian Online Go.in. This is the website, you can note it, and you can file the patent through this particular website. And here in case of offline, you can do by physically by submitting the printed documents because already different forms are there. You have to fill it, you have to sign, and finally you have to submit in the patent office. Then filling location, I already told you, it can be done from anywhere in case of online because you have internet access. Here we can only file at the Kolkata, Delhi, Mumbai, and Chennai. Filing medium, electronic document here required. Here in case of hard copy are required. User requirement, digital signatures are required. Here only physical signatures are required. So this is the difference. Time efficiency, instant submission, acknowledgement, everything. Here once you submit the form, it will go to the system. It will take time. It's know already very well. Then transparency, applicant can track the online application. Like suppose what is the status, you can track online. Here you can see require manual inquiry communication with patent office. So many things are required. That's why nowadays everybody is going through the online services. Preferred for researchers, startups, institutes. Applicant with limited internet, like suppose those who belong to village. Nowadays village people also, I think nowadays even scientists, professors are filing patent. So they generally have access of computers, so they can file patent from the city also. Okay, so these are the detailed forms. Because for filing any patents, you have to fill different forms. Like you can see, form 1 is application for grant of patents, content, applicants, inventors, title details. File at the beginning. So this is mandatory form. Then form 2, provisional or complete specification. Describe invention in detail. This is also provisional. Then 3, a statement undertaking, mandatory for all applicants. Form 5, declaration as to inventorship. You have to declare like this is the novel article work. Okay, and then form 9, request for early. See, this is very important step. Request for early publications. Even generally it takes around 18 months to publish. But if you are interested, you can file that I want early publication. So in that case, you have to again pay the money and your patent will be published. Then form 26, power of attorney. Like suppose if I study some what you call Ali told you somebody is not interested, so you have to give certain power to the certain person. So in that case, patent agents file the applications. Form 28 to claim a small entity or a startup. This is also optional. If applicable, you can go through it. Okay, so this is the fee. Some important fee for filing patent. I already told you, if you are filing individually, you have to pay 1/4 time fee. You can see if you are filing through institute or some legal entity, you have to pay 4,000. If you are filing individually, you have to pay only 1,000. So only you can see here everywhere 400, 100, 800, 200, 10,000, 2,500. So if you are filing any patent individually, you have to pay 1/4. See the difference. Like DI is the non-proprietary institute, so you can file patent alone. Like your head, mechanical engineering head, he has filed many patents alone. So that's why he used to pay only limited money. Okay, now you can see the conditions. If you see the state-wise, so Tamil Nadu is the state who has filed many patents. Because I number of filing, I'm telling this is the, you can see more than around 8,000. Highest patent filed by the Tamil Nadu. And see, if you see all the Union Territory, Lakshadweep, like second is Maharashtra, third is Karnataka, then fourth is Delhi. Our Uttar Pradesh, I think 1, 2, 3, 4, 5, 6 positions is there. So that's why you can see Tamil Nadu had more intellectual person. You can tell in other words, they are more interested in patents. So that's why they are filing. They know how to preserve our creations, how to legal. And one of the, again, I am telling you, this is the GK. The individual with the most patent is the Japan Snoopy Yamazaki. 20,000 patents he is having. 20,000 papers. And in whole world, China is the number 1. China is the number 1 in the highest number of patents are available. And India ranks 6th position globally in patent filing in 2023. So see our condition. We are earlier we are 9, but 9 we came down to the 6, but still China is number 1. So that's why I'm telling in your life, if you file 5, 6 patents and if you commercialize, so by just sitting, ideally you can generate income, you can eat, you can enjoy your life. Okay, so these are already I discussed, like step is that filing, publications, examination, opposition, grant. So already I told you this is the not noble already discussed withdrawal. So here you can see here. So filing, I told after 18 months it will be published. Then a request for examination. Again you have to go for request for examination and issuance of first examination report. Okay, then you get the report. If everything is okay, then finally filing response, grant. Then finally we'll get the your patent number. But suppose After publication, you can see pre-grant opposition. If somebody is just given supposition, some complaint, then again it is just hearing will be done, then decision, then if not found, then it will be refused. So again, I will show example in my case also. I just want to give example. So you can see here. So this is the application. Then publication will take 18 months. Then request for examination 48 months. Okay. Then again examination, first examination report, response to office action, the grant of patent. So these are different procedure. And again, I am telling one more thing. Like suppose those who are believe in publication, publishing the article. First, you have to file the patent, then you can submit the manuscript, or it should be go for publication. Means you have to report in the patent office first. If your invention are already published, you cannot file patent. Are you getting my point? अगर आपने पब्लिकेशन कर दिया, उसके बाद सोचोगे कि हम पेटेंट फाइल करते हैं, तो आपका पेटेंट नहीं होगा. So that's why first you have to report in the patent office. These are my findings. First you report, then your paper should be published, because people generally in our case, if we are publishing also and we are filing patent also. So first you have to file the patent, then it should go for publications. So that is a very, very important step. Okay, so what is the advantage? Just I told you, this is the one can protect the predetermined period. Okay, even you can get the incentives, revenue for the business. Okay, you can see here. So it provides intellectual property right, helps you to earning from your own invention. This is the very, very important. You are getting incentives, you are getting money. Safeguard your invention for period of 20 years. Because you have got legal right. So you are, this in 20 years, nobody can steal you, nobody can take you anything. Creates an asset for an enterprise. This is your asset. So these are different benefits of patent registrations. This is the disadvantage. This is the key. Although everywhere, high advantage, there is called pros and cons. So maybe it is cost effective. Every like signing also you have to pay for RQ. That is called exemption fee. Also you have to pay renewal. Also you have to pay. So every year you have to pay the money. So that's why it may be expensive, but not always. So that is cost, time, loss of information, exploitation of inventor, invention by inventor, and infringer. So I just want to give you example. See, this is the, like suppose in from Dalbag, I also want to file a patent. You can see here. So this patent is already published. You can see already published. Already published, like this is the Dalbag Ajiranjan. So already published. Now just 2 days before I got some of the questions. They have asked certain questions. You have to defend it. Why my patent is important? Why my patent is noble? So after defending, it will be granted. But already I told you some of the patent already granted. And again, I think 10 days back, this is the copyright. This is the certificate of copyright. You can see this is the patent certificate, and this is the copyright. So recently, one got copyright from the Delhi office. So already this is granted. So these are all done. Now renewal fee, I want to tell you. So to be paid within 36 months from the date of recording in the register fee. So I already told you, no fee for first and second year. Renewal fee on yearly basis, it is required to be paid from 3rd to 20th for keeping the patent in the force. So these are the different fee I already told you. And these are the references. So you can go to the references like indiapatents.org.in, typec.org, Elsevier, signed at Google. These are the things. Thank you very much. If you have any doubts, you can ask. But always remember, I already told you, first file a patent, then go for publication. After publication, you cannot file a patent. That is very, very important. Okay. And second point, always try to see whether it is patentable or not, or it has certain IPR or not. Maybe in form of copyright, maybe go for patent, anything. So that's why now you have to protect your asset, protect your right in different forms. Any questions? आप लोग समझ में आया कि नहीं आया? तो ये 20 ईयर्स के लिए होता है आपका। हाँ बोलो बोलो।
लिमिटेड टाइम के लिए क्या होता है?
अगर आपको जैसे लाइफ काउंसलिंग करेगा तो आपको कैसे मिलेगा? इसलिए सर्टेन 20 ईयर्स दिया जाएगा। आप इस पर ओपन है, उसको यूज कर सकता है। अगर चाहे तो उसको लीवर भी करा सकते हैं। आप चाहिए फिर से चाहिए तभी लीवर करा सकते हैं। तो चीज जाएगा नहीं कर सकते एनडी फाइव ईयर्स हर बंदी आप बता लेंगे।
सर मेरा क्वेश्चन था कि जैसे हमें कोई चीज पेटेंट करानी है, कोई प्रोडक्ट, तो हम अपनी रिसर्च कैसे कर सकते हैं कि वो चीज ऑलरेडी पेटेंटेड है कि नहीं?
देखिए मैं बताना चाहता हूँ, ऑलरेडी पेटेंट का एक अपना पब्लिकेशन रिपोर्ट है, अपना पब्लिकेशन जो है ना फाइल है। आप पहले देखिए उसको कि ये चीज किसी ने पेटेंट पहले से फाइल किया कि नहीं किया है। जो बताया था ना अभी आपका आईपीआर जो है वेबसाइट है, उसमें आप देखिए कि इस तरह का पैटर्न कोई किया कि नहीं। क्योंकि बता दिया, अभी बताया था कि कोई भी पैटर्न पब्लिश करेंगे तो ऐसे ही वो लोग देखेंगे कि ये कोई पहले से है कि नहीं है। जो भी आपका जो होता है ना एग्जामिनर होता है, पैटर्न एग्जामिनर होता है, बोलते हैं कंट्रोलर एग्जामिनेशन, वो जो कंट्रोलर होता है वहां भी कंट्रोलर बैठता है, वो वेरीफाई करता है कि जो आपने पैटर्न फाइल किया है ऐसा तो नहीं किसी से चुराया हुआ है, यदि कॉलेज से एग्जिस्ट करता हो तो आप भी सर्च कर सकते हैं, ऑनलाइन सर्च कर सकते हैं, गूगल सर्च कर सकते हैं, या पैटर्न का एक अलग पब्लिकेशन है तो उसमें सर्च कर लीजिए, देख लीजिए वो है कि नहीं है। अगर नहीं है फिर कोई बात नहीं है, आप सर्च करके देख सकते हो कि ये पैटर्न नोवेल है कि नहीं है। फिर अपने पूछिए, हालांकि आजकल सर्च करने के बाद पता चल जाता है कोई भी चीज हो।
क्यों सर?
और कोई क्वेश्चन है? आप लोग समझ में आ गए? पीछे जो बच्चे हैं, हेलो, समझ में आ गया आप लोगों को? हालांकि ये 2 दिन का सेशन है, बहुत कुछ सुनने को मौका मिलेगा। और मैं भी बता दूं कि मैं भी अभी 2 ही पेटेंट मेरा ग्रांट हुआ है, अभी 2 फाइल किया हूं। तो आई थिंक वन ऑफ माय फ्रेंड ही इज ऑलरेडी पेटेंट ऑफिसर इन दिल्ली ऑफिस। तो मैं भी उससे पूछता हूं कि यहाँ पे ये प्रॉब्लम आ रहा है कि क्या किया जाए। कुछ टेक्निकल इश्यू है तो इसलिए कर रहे हैं कि पेटेंट फाइल करके ग्रांट करना एक अलग स्टेप है, लेकिन जो पेटेंट ऑफिसर हैं वो सारे चीजों को हैंडल करते हैं कि हाँ यहाँ पे ये प्रॉब्लम है, यहाँ पे ये प्रॉब्लम है। जैसे कि एक और चीज, जैसे मोस्ट क्वेश्चन है, जैसे कॉमन क्वेश्चन है कि क्या एक ही पेटेंट को 2 कंट्री में फाइल किया जा सकता है? तो इसका भी आंसर यस हो सकता है। आप यहाँ फाइल कर दीजिए विद इन, जैसे आपने पढ़ा होगा पेरिस कन्वेंशन, उसमें पेरिस कन्वेंशन कहता है कि विद इन 1 मंथ आप दूसरी जगह भी फाइल कर सकते हैं। तो बहुत सारे रूल हैं, आपको रूल पढ़ना पड़ेगा बहुत सारे इसमें, जो है ना, ऐसा नहीं कि जो मैं बता दिया यही है। और भी टीचर और भी एक्सपर्ट आपको बताएंगे कि पैटर्न के बारे में क्या। तो आप जब सारे टॉक सुन लेंगे तो आपको ओवरऑल आइडिया हो जाएगा, ओवरऑल पिक्चर मिल जाएगा। फिर आप कोई पैटर्न फाइल कर सकते हो, क्योंकि ड्राफ्टिंग भी इशू है। पैटर्न कैसे ड्राफ्ट, जब मैं बताया नहीं, उसमें क्लेम्स करते हैं। अभी बताया था कि 10 क्लेम, एक बार पैटर्न फाइल कर सकते हो तो 10 क्लेम तक पैसा नहीं लगेगा, मैंने पैसा लगेगा, उससे ज्यादा क्लेम करोगे तो पैसा आपका बढ़ जाएगा। तो कितना क्लेम करे ये भी इंपॉर्टेंट है। जो भी आप ड्राफ्टिंग करे, ड्राफ्टिंग में वो लिखते हैं क्लेम 1, क्लेम 2, क्लेम 3, क्लेम 4, तो कितना क्लेम करे वो भी इंपॉर्टेंट है। ऐसे सब लिखने के आपको आर्ट होना चाहिए, कैसे लिख रहे हैं, कैसे अपने चीजों को डिफेंड कर रहे हैं, तो ये भी आर्ट है ये।
Thank you, sir, for your informative presentation. Now I request Mr. Manoj Kumar, sir, to felicitate Mr. Rajiv Ranjan, sir. Moving ahead, we now have Dr. Ishan Singhal, sir, with us for session 2. Dr. Ishan Singhal is an assistant professor in civil engineering at the Albag Educational Institute, Agra. He holds a BTech and PhD from DEI and an MTech from IIT Delhi. His research focuses on 3D printing, additive manufacturing, and geoinformatics. Dr. Singhal has published extensively, holds Indian patents, and has received research grants from agencies like Ministry of Education, AICTE, and TQIP 3. He is also the course coordinator for MOOCs, IIRS ISRO, and has been recognized with medals for academic excellence in BTech and MTech. Sir, I request you to please continue the session.
Thank you for the nice introduction. So you will find most of the things are overlapping, and I guess that's a good idea to have the better understanding about the IPR. I will be giving you about the overview of intellectual property rights, and one aspect of IPR is already been discussed by Dr. Rajiv Ranjan. So once again, good afternoon, dignitaries, colleagues, and students. Today, I, Shan Singhal, working as assistant professor in the Department of Civil Engineering, Dayalbagh Educational Institute, Agra, will be delivering a talk on the topic Understanding Intellectual Property Rights, IPR. Now, the first question which comes in our mind is how many of you have ever had an idea and wondered how that idea can be protected? Now, in today's world, ideas are assets, whether it's a design, it's a technology, creative work, or protecting intellectual effort is very crucial because, like the name suggests, it is intellectual property. So this comes, your ideas are basically the part of your intellect. So now let us explore what IPR means, why it matters, and how it operates globally and in India. So the first question which comes in our mind is what is intellectual property, which is called as IP, and it is defined as the creation of the human mind. जो आपका दिमाग सोच रहा है, that is being protected. Now this is an intangible wealth. It can be an invention, it can be an artistic expression, it can be a literary work, or a distinctive symbol or design. Now, this is breakdown into two parts, broadly into two parts, copyright and industrial properties. Copyrights, like the sir has already discussed, this protects the artistic, creative, and literary work, whereas industrial property includes the role of commerce, which has trademarks, patents, industrial design, and confidential information, which is also called as trade secrets. Now, there is a special category which is called as GI, geographical indication, which protects the products originating from a specific location, like Agra Peta, Darjeeling tea, and there are many more such examples. So, in essence, IP gives creators ownership over their ideas, just as physical property gives ownership over lands or goods. Now, what is the scope of IP? IP covers vast field. The formal definition includes rights relating to the literary, artistic, and scientific works. It also includes invention of all fields. It includes trademarks, commercial names, and designs, and even protections against unfair competition. So, in short, it is a legal recognition for the output of intellectual activity. Now we all know what tangible properties are: land, house, car. These all are tangible properties which you can touch, you can feel. Whereas intangible, you cannot touch, but they carry huge values like idea. So it's an idea, brand, or a process. They are intangible, makes it uniquely vulnerable. Once created, it can be easily replicated at almost zero cost. So think of a song or a software that can be easily copied infinitely and almost at negligible cost. That's why the law steps in to protect these invisible assets and ensure creators receive both credits and reward for their work. Now, what is the role of IP as intangible property? IP protection does more than safeguard idea. It provides economic rights to the creator. It encourages commercial views of innovation. It helps in technology transfer and also contributes to cultural growth. So by protecting IP, societies build an ecosystem where creativity thrives and innovation gets recognized. Why do we protect intellectual property IP, or why do we grant these protections? That is the question. It's an incentive system. It can reward capital expenditure. It also allows to put efforts into the research and development and also in the marketing field. It allows creators and companies to profit from their innovations, inventions, and also fund future innovations. It prevents freeloaders from simply copying a successful product. It maintains a brand loyalty and enables the transfer of technology. So ultimately, this promotes economic progress and also helps in the public trust. Now, like we have said, intangible and tangible products, we know that tangible products as property, but these IP also act as a property. These behave like a physical property which can be sold, leased, licensed, inherited, or it can be transferred. For example, a software company don't sell the ownership. Instead, they license the usage rights and generate recurring income. So that is one example of IP as a property. And this is the foundation for the commercial value of the IP. Now, what is the legal framework for IP? That has already been, some part of has already been discussed. So India's IPR framework is overseen by the Controller General of Patents, Design and Trademarks, which is abbreviated as CGPDTM, under the Department of Promotion for Industry and Internal Trade, that is DPIIT. And this is majorly three parts, which is the IP office, external machinery, and the course. IP office basically handles the filings and the registration. External machineries comprises of the patents agents, examiners, and legal experts, and the courts which enforce and interprets the IP laws. And this all information is available on the website ipindia.gov.in. So if you want, you can access and you can get the details of all the different toolkits of the IP, whether it is copyright or trademark or patent design or your confidential information. So you can get all the details about them. Now, a brief how globally IP is protected. Like sir has already mentioned about the Paris Convention. So there are different acts and conventions which helps in the protection of the IP, which is one of them is Paris Convention in 1883, that is for industrial property. Berne Convention in 1886 for literary and artistic works. Rome Convention in 1961 for performers and producers. Then we have TRIPS, which is called as the trade related aspects of intellectual property rights agreement, which is done in 1995, which standardizes the global IP rules. Then we have nowadays WIPO convention, which is helps in the establishing the World Intellectual Property Organization, and all these ensures your innovations and creations that is being recognized beyond the national borders. Now, what is the intellectual property toolkit? It has copyright, industrial property, and a special category of GI, geographical indication. And like discussed, copyright, industrial properties include the trademarks, patents, industrial designs, and confidential information. Each category has its own legal framework. They have different legal frameworks and duration of protection, and together forming a shield for their around innovation. Now we will discuss shortly about all these toolkits. So let us first discuss about the copyrights. Copyrights protects the expression of an idea, not the idea itself. It covers literary, artistic, musical, and film works. Even the softwares are also categorized under the copyrights. India does not patent the software, so that is under the category of the copyright. So these protections they last for This also, it depends upon the work, which is like in the case of the literary activity, it is the author's lifetime plus 60 year, and in most of the works, it is around 60 years. So it grants both commercial and moral rights to make copies, to sale, and also the authors are being credited if you have the copyright. In India, registration is not mandatory for the protection through, though it serves as excellent evidence in the court. Now, what about trademarks? So, trademark is a mark that identifies your goods and services. It can be a name, logo, slogan, or even a color scheme. So, you can think of an Apple logo or Amul brand, they come under the trademark. Its purpose is to build brand identity and customer trust and guarantee quality. It can be a registered trademark or unregistered trademark, but registration provides much stronger and legal enforceable rights. So, in India, it does not protect the sounds and smells. This doesn't come under the category of the trademarks. Now, the patents, which you all are thinking of, patents are often called as the crown jewel of the inventors. A patent is a deal between the inventors and the government. The inventor discloses all the details of the invention in a public document. So you can find the details of any patents which is available on the website. And in return, the government gives the monopoly to commercially exploit the patent for 20 years. Okay? And to be patentable, there are three aspects, that is the novelty, incentive steps, and it should have industrial application. So these are the three aspects which one should consider before applying the patent. India's follows first to file system. So speed is crucial. Be the first to file the patent. In return, investors fully disclose their methods in the patent document, which enrich the public knowledge. Now, next is industrial designs. Designs rights protect the look of a product. It can be shape, configuration, um, anything, but how it functions, that is not important in the case of the design. Think of a unique shape of the Coca-Cola bottle, that can be a design, or a new car design that comes under the industrial design IP. But the design must be new, original, and it should be appealing to the eye. It must be applied to an article by an industrial process. Next, GI. GI is a sign used on goods that have a specific geographical origin and possesses qualities or a reputation due to that origin. For example, Darjeeling tea, Banaras sari, Kashmiri pashmina, Kanchipuram silk, those all are examples of GI. And it stops producers from outside the region from using the name and protecting the traditional knowledge and reputation of the local producers. Now there's a law called law of tort, and tort is basically the breach of some duty which is independent of contract. This is used for the protecting the confidential information. So apart from legislation, the common law, which is called as the principle of tort, protects the confidential information. This applies in employer-employee relations, business partners, and even private contracts. For example, it can be a client's list, it can be a secret ingredient, it can be a Coca-Cola recipe, or any other formula. So that is why this is guarded by as trade secrets or called as the confidential information. The key test to have the confidential information is that the information must be confidential and it should not be misused by the recipient. Now, once you have the IP, then how to enforce that IP? That is a big question. Having an IP is one thing, but we need to enforce it. So there are different aspects which can be a civil action, criminal prosecution, cost in litigation, assistance from enforcement division, and being vigilant, self-help. So the first one, which is the civil action, in this case, you can sue the infringer. Advantage include that you may get the monetary compensation for the damages, and in turns, you can have injunctions. That is, the courts may stop the activity. But the downside is the cost. It incurs some cost. Then the next one is the criminal prosecution. You file a complaint with the police, the state bears the cost and can result in fines and imprisonment of the infringer, but there is no monetary compensation in the case of the criminal prosecution. Now the question comes, what is infringement? Infringement basically means the unauthorized use of the protected IP. Now this can be direct or indirect. Uh, it is further categorized as the contributory, which is the primary infringement, and vicarious, which is called as the secondary infringement. In the primary infringement, it basically knowingly facilitate the infringement. For example, a shopkeeper provide photocopy of the pirated books. So that can be considered under the primary infringement. And in the case of the secondary infringement, it is the action of the infringing person indirectly. Like for example, uh, if there are copying of the pirated CD of some music, or you can say some movie, so the landlord in which the activity is being carried out, that will be categorized under the secondary infringement. He has no direct involvement in the infringement, but because that activity is being carried in in his house, or the area, that will be that person will be categorized under the secondary infringement. Then there comes another aspect, which is called as the fair use or fair dealing. This allows the limited use of the copyright work without the permission for the purpose, like for example criticism, news reporting, and even in teaching and research we can use limited part, but that depends what is the purpose and how much amount of the infringement has been carried out. Now IP is an asset that we know, and value is always realized with the commercialization. So the primary ways are sales and the assignment come into the same category, in which you transfer the ownership permanently to some other person. So that will be categorized under the sale and the assignment. Then we have licensing, in which you grant the permission to someone else to use your IP for a fee, or which is also called as the royalty. Now this has two categories, exclusive and non-exclusive. Exclusive is that you grant the permission to only one person, and whereas non-exclusive means you are granting the permission to multiple parties. That comes under the non-exclusive category. Now there are category which are called as paralegals, and paralegals are basically unsung heroes of IP managements. Their role is to prepare and file registration applications, monitor deadlines for renewals, act as a license with clients, draft license and employment agreements, assist in IP audits, and protecting trade secrets. Now, like one was asking, there can be misuse of IPR. So while IP encourages innovation, but over protections can hinder progress. So there are some examples which are Gillette blades and molten salt. So when the rights are extended beyond reason or used to block competition, that is called misuse. And cases like Gillette blades, I discussed. So what happened is, in the case of the Gillette blades, the company patented the blade handle. The company patented the blade handle, and then companies sold that blade handle at a very low price or free of cost. It is given to the consumers. Then what it does is, they have unpatented blades, and that was sold at the higher price. So that is called the misuse of IPR. And similarly, there was a case of molten salt, where a company called, I guess, GS Private Limited, what they did is they designed a machine which packs the salt, and then the machine was patented. So but that machine was only designed for the molten salts. So indirectly what it does is, it basically publicize, or it basically let the producers to use only molten salts for packaging the salts. So these are the misuse of IPRs. So healthy competitions and open access are always essential for the long-term innovations. Now, what is the history of IPR? Globally, IPR is coordinated by the World Intellectual Property Organization, WIPO. Its origins go back to the 1883 Paris Convention and 1886 Berne Convention. It evolved from BERPI, which is a French acronym. Uh, to become a specialized agency of the United Nations in 1974. So WIPO now coordinates global IP services, treaties, and dispute resolution. Now, with digital age, there are challenges associated. Now, the challenges are online piracy, software duplications, and AI generated content. And the technologies like digital watermark, encryption, and blockchains, they can help in track and protect the digital assets. Now, to conclude this part, I can say that intellectual property is a powerful tool for protecting your creativity and innovation. It is for rewarding your investment and efforts, and it also derive economic and cultural development. So whether you are an artist, engineer, scientist, or a business owner, understanding IP is crucial and to safeguard your work and to thrive in the modern economy. So that was about the overview of the IP. Now I have also included some patents which were filed and ultimately granted by our group. So this is our first patent, which has not yet been granted. It is in the process. So it is just to give you a timeline that this patent was filed in 2020 and it is in the process of granting. So this was a patent where we have designed a extruder for a 3D printer, and this basically comprises this extruder. Not the 3D printer was patented, the extruder of the 3D printer was patented, and there was 4 parts. And the first part, which you can see on the left hand side, the first part was the auger, which has the spiral blades, and then we have a casing, the top cover, and the bottom attachment, which has the square orifice. So the idea was to extrude the concrete, and as you know that the concrete has a property of the settlement, so this auger has a continuous rotation mechanism so that this prevent the settling of the concrete. So this is just an idea that initially we have filed 9 claims. So claims are very important in the case of the patents. So initially we have filed the 9 claims, and this was the very first patent. We have no idea how to file the patents, and they were randomly written. So we get FER, first examination report of the patent, and there were so many comments. We addressed all the comments and then revised the claims accordingly. And what I learned out of these claims, that you should always write the first claim in the 2-part forms. 2-part forms basically means you should have the first part, which basically discloses the information which already exists about the patent, and then in the second part you will disclose the invention, what is the innovative idea you are proposing. So in this case, since the 3D printer is already known, what we propose is the extruder. So we have written in the 2-part form, and then accordingly we have modified the claims and then resubmitted. And finally, we are expecting the grant of this patent. And there are other 2 aspects, other patents, which is one system and method to simulate 3D printer machine. Uh, in India, you can only file patents for the products in process. You cannot get the patent for the software. So we filed this as a process, not as a software. And this was a process where a person sitting at home can print a 3D part at some other location. So that is what we have told them. And as you can, if you can see the timelines, this was filed in 2020 and ultimately granted in 2023. So that is the time taken in filing and then ultimately getting the patents in your hand. And this is another patent, which is a methoded system for making silicon washer and gaskets. So what we did is we have an extruder for this, of silicon, which basically produce or make the silicon washers and gaskets. So in this also, if you see the timeline, this was also filed in 2020 and ultimately granted in 2023. And the last was the foldable freeform fabricator, which is a portable 3D printer. So we thought there is no such printer which can be easily carried to different locations. So we have designed this and then again filed a patent, and then we get this patent in 2024. So it took almost 4 years to get the grant of this particular patent. So that is the timeline which is usually there. So thank you for the patience hearing. If you have any question, I am open to that. If there is no question, you can come to me personally and I can answer your questions as well. That is not the issue.
Thank you, sir, for your valuable contribution. Now, again, I request Mr. Manoj Kumar, sir, to felicitate Dr. Ishan Singhal, sir. It's now time for lunch. Delegates kindly proceed to the International Seminar Hall, and participants are requested to have their lunch outside this hall. We'll reassemble at 2 p.m. for the post-lunch sessions. Also, the students who are left for their attendance are kindly requested to sign the attendance sheet.
Kindly pay attention. The lunch will be distributed here only. Please be seated.